Welcome, dear students, to yet another lecture on family law. The topic of today's deliberation is the Uniform Civil Code. The objectives of this lecture are to understand what is meant by the Uniform Civil Code, to understand the historical background of the Uniform Civil Code, to understand the legislative reforms that have taken place in this field, and lastly, to understand the judicial approach to the Uniform Civil Code. Now, let's start with the introduction. Uniform Civil Code is a term which basically originated from the concept of civil law code. No one is oblivious to the fact that India is a pluralistic country with diversity of religion. People belong to different religions possessing different kinds of faith like Christians, Muslims, Sikhs, Hindus, Parsis, etc. And all these sects possess different sets of personal laws, most of which derive their authority from their respective religion or ethnicity. The common areas falling under the domain of personal laws are personal status, the rights related to the acquisition or administration of the property, marriage, divorce, adoption, inheritance, etc. All such matters are dealt according to the personal laws of a particular religion to which the person belongs. The Uniform Civil Code envisages the administration of these persons or citizens belonging to different religions with the same set of secular laws, and this supersedes the right of the citizens to subject themselves to different personal laws based on religions or ethnicity. The Constitution of India lays down that the administration of the Uniform Civil Code for its citizens as a directive principle envisaged under Article 44, which requires that, and I quote, "The state shall endeavour to secure for citizens a uniform civil code throughout the territory of India," unquote. So, the Uniform Civil Code has an object to introduce uniform personal laws for the purpose of national integrity, fraternity, and national consolidation, and proceeds with the presumption that there is no necessary connection between religion and personal laws. The word civil used in the article refers to what is known by the expression civil law, which means law relating to private rights of a person as distinguished from public rights, and would relate to various aspects of personal relations such as contracts, marriage, inheritance, etc. Also, another term, personal law, usually refers to the laws governing personal family matters regardless of where the person goes. India as a country is a single territorial unit wherein different systems of law govern different classes of citizens in respect of the same matters like marriage, inheritance, divorce, etc. The laws in this limited field are personal, applying only to a definite class, such persons being governed in many respects by their personal religious laws. Though many areas of civil law have already been codified in enactments applicable uniformly to the entire population, like the Civil Procedure Code, the Evidence Act, the Transfer of Property Act, but there have been objections and resentment on the part of several groups against the unification or uniformity of personal and family laws such as marriage, adoption, divorce, inheritance, succession, etc. Voices were raised against such unification, and it is because of this controversy that this provision was put under the directive principles of state policy. Also, another reason for the non-interference in the matters of personal laws has been that India is a secular state and that the identity of minorities would be respected in all circumstances. Now, dear students, let us have a look at the historical background of the Uniform Civil Code. The historical background is divided into two parts. The first part is the colonial period and the second part is the post-colonial period. First, we start with the colonial period. The debate for a uniform civil code dates back to the colonial period in India. The Lex Loci report of October 1840 laid emphasis on the importance and necessity of uniformity in codification of Indian laws relating to crimes, evidence, and contract. However, it recommended that personal laws of Muslims and Hindus should be kept outside the purview of such codification. According to their understanding of religious divisions in India, the British separated this sphere, which would be governed by religious scriptures and customs of the various communities, that is, Hindus, Muslims, Christians, and later Parsis. These laws were applied by the local courts or panchayats when dealing with regular cases involving civil disputes between people of the same religion. The state would only intervene in exceptional cases. Thus, the British let the Indian public have the benefit of self-government in their own domestic matters, with the Queen's proclamation of 1859 promising absolute non-interference in religious matters. The personal laws involved inheritance, succession, marriage, and religious ceremonies. The public sphere was governed by the British and Anglo-Indian law in terms of crime, land relations, laws of contract, and evidence. All this applied equally to every citizen irrespective of religion. In many Hindu and Muslim communities, there was a variation in scriptural and customary laws. Sometimes they were even in conflict with each other. For example, the Shudras allowed widow remarriage, which is prohibited by the Hindu scriptures. It is important to remember that Hindu laws were preferred by both the British and the Indian judges because they were comparatively easy to implement. Also, they feared opposition from the high caste Hindus. Customary laws were hard to implement because it required investigation into specific practices of communities on a case-by-case basis. Towards the end of the 19th century, individual customs and traditions gained greater recognition. With regard to Muslims, the Muslim personal law or the Sharia law was not strictly applied. This was because of the lack of uniformity in its application at the lower courts. Bureaucratic procedures were also responsible for its hazy implementation. As a result of this, customary law, which was often more discriminatory against women, gained prominence. Women, mainly in northern and western India, often were restrained from property inheritance, even though the Sharia provides for the inheritance of women. Later on, the Sharia law of 1937 was passed, which stipulated that all Indian Muslims would be governed by Islamic law on marriage, divorce, maintenance, adoption, succession, and inheritance. Now, dear students, let us take a look at the legislative reforms in the colonial era. The Hindu law discriminated against women by depriving them of inheritance, remarriage, and divorce. Under the British rule, certain legislative reforms were made which aimed at ameliorating the condition of women, especially that of Hindu women. These included the Indian Succession Act of 1865, the Indian Marriage Act 1864, the Hindu Widow Remarriage Act of 1856, Married Women's Property Act of 1923, and the Hindu Inheritance, Removal of Disabilities Act 1928. Dear students, another point that we have to remember is a committee called the B.N. Rao Committee was set up to determine the necessity of a common Hindu law. The committee aimed at reforming Hindu laws in accordance with the scriptures. The committee recommended a civil code of marriage and succession. It was set up again in 1944 and sent its report to the Indian Parliament in 1947. Another act which requires special mention is the Special Marriage Act 1872. This act was passed which gave the citizens an option of civil marriage. Initially, the act was applicable only to Hindus, but later on, by the Special Marriage Amendment Act 1923, Buddhists, Sikhs and Jains were also permitted to marry either under the personal laws or under this act. This was also a step towards unification of personal laws. Now, dear students, we shall understand the developments post-colonial period. After India became independent, the Uniform Civil Code was a highly debated issue in the Constituent Assembly. Pertinently, the Uniform Civil Code was originally encapsulated in Article 35 of the draft Constitution. On one side, Dr. B.R. Ambedkar, supported by other eminent nationalists like Gopalaswamy Iyengar, Ananthaswamy Iyengar, K.M. Munshiji and others, were in favor of the Uniform Civil Code, whereas it was strongly opposed by other members. These included Muhammad Ismail Sahab, Naziruddin Ahmad, Mehboob Ali, Beg Sahab Bahadur, Poker Sahab Bahadur and Hussain Imam. When the issue came up for discussion in the Constituent Assembly, Muhammad Ismail Sahab, Naziruddin Ahmad, Mehboob Ali, Beg Sahab Bahadur, Poker Sahab Bahadur and Hussain Imam vehemently opposed the article, which said, and I quote, "The state shall endeavour to secure for citizens a uniform civil code throughout the territory of India," unquote. Beg Sahab Bahadur claimed that as far as Muslims were concerned, their laws of succession, inheritance, marriage and divorce are completely dependent upon their religion. Other Muslim members echoed this sentiment. Muhammad Ismail Sahab claimed that a uniform civil code will generate disharmony, whereas if people are allowed to follow their own personal law, there will be no discontent. Poker Sahib Bahadur claimed that the article was a tyrannous provision which ought not to be tolerated. Beg Sahib Bahadur put forth a convoluted interpretation of secularism. He said that in a secular state, citizens belonging to different communities must have the freedom to observe their own life and their own personal laws. Poker Sahib Bahadur claimed that it was the duty of the majority to secure the sacred rights of every minority. On the other side, K.M. Munshi took a very rigid view in negating the claims of majoritarian oversweep over the minorities. He stated, and I quote, "It is not therefore correct to say that such an act is tyranny of the majority. If you will look at the countries in Europe which have a civil code, everyone who goes there from any part of the world and every minority has to submit to the civil code. It is not felt to be tyrannical to the minority. The point, however, is this: whether we are going to consolidate and unify our personal laws in such a way that the way of the life of the whole country may in course of time be unified and secular. We want to divorce religion from personal law, from what may be called social relations, or from the rights of the parties as regards inheritance or succession. What have these things got to do with religion? I really fail to understand," unquote. Dr. B.R. Ambedkar was another staunch supporter of the Uniform Civil Code. He stated, and I quote, "I quite realize their feelings in the matter, but I think they have rather read too much into Article 35, which merely proposes that the state shall endeavour to secure a civil code for the citizens of the country. It does not say that after the code is framed, the state shall enforce it upon all citizens merely because they are citizens. It is perfectly possible that the future Parliament may make a provision by way of making a beginning that the code shall apply only to those who make a declaration that they are prepared to be bound by it, so that in the initial stage the application of the code may be purely voluntary. Parliament may feel the ground by some such method. This is not a novel method," unquote. Since the Uniform Civil Code was hotly debated and was also a politically sensitive issue, the founding fathers of the Constitution arrived at an honourable compromise by placing it under Article 44 as a directive principle of the state policy. Thus, Article 35 of the draft Constitution of India was added as a part of the directive principles of state policy in Part 4 of the Constitution of India as Article 44. This meant that it was not justiciable in nature. This meant it could not be enforced by the courts. It was incorporated in the Constitution as an aspect which would be fulfilled when the nation would be ready to accept it, and the social acceptance to the Uniform Civil Code could be made. It aimed at gradually achieving, rather than at once, far-reaching equality for all citizens. However, to this day, the Uniform Civil Code remains to be a constitutional dream yet to be fulfilled. Presently, Goa is the only state which has the Uniform Civil Code. The judiciary has time and again reminded the legislature of the need to have a uniform civil code through its various judgments. Two important developments that merit mention here is, one is the codification of Hindu law and the second is the passing of the Special Marriages Act. In the year 1955, the Prime Minister of India, Jawaharlal Nehru, thought of codifying personal laws, but it was obstructed by orthodox elements as it promoted monogamy, divorce, and equal division of property between son, daughter, and widow, adoption, maintenance to wife, etc. But later on, Nehru was convinced and brought in the Hindu Code Bill in the same year. The major criticisms to the code were that it did not touch upon the Muslim community. Therefore, a lesser version of the Hindu Code was passed after a long opposition in the Parliament between the 1955 and 56 sessions in the form of 4 separate acts. These were the Hindu Marriage Act, the Succession Act, Minority and Guardianship Act, and Adoption and Maintenance Act. Now we must also make mention of the Special Marriage Act 1954, which was passed. This act provides a civil marriage to any citizen irrespective of religion, thus permitting any Indian to have their marriage outside the realm of any specific religious personal law. The law applies to the whole of India except the state of Jammu and Kashmir. Under this act, polygamy was illegal and inheritance and succession would be governed by the Indian Succession Act rather than the respective personal law. Divorce would also be governed by the secular law and maintenance of a divorced wife would be along the lines set down in the civil law. Pertinently, if two Hindus marry under the Special Marriages Act 1954, their inheritance would be governed by Hindu law rather than the Indian Succession Act. Now, dear students, we take a look at the judicial approach to the Uniform Civil Code. Over the last several decades, the Supreme Court of India has strongly advocated for the implementation of the aspirations laid down under Article 44 of the Constitution by unifying the personal laws of different communities. This approach of the judiciary can be deduced from a number of decisions passed by courts wherein the courts favored the implementation of unification or unanimity of personal laws, that is, the Uniform Civil Code. The court has impliedly given nod to the implementation of the Uniform Civil Code, but it has left the job for such implementation in the hands of the legislature. Now let us examine some of the landmark cases which determine the judicial approach towards the implementation of the Uniform Civil Code laid down under Article 44 of the Constitution. In Jordan Denede versus S.S. Chopra, the court observed, and I quote, "Law relating to judicial separation, divorce and nullity of marriage is far from uniform. Surely the time has now come for the complete reform of the law of marriage and to make a uniform law applicable to all people irrespective of religion or caste. We suggest the time has come for intervention of the legislature in these matters to provide for a uniform code of marriage and divorce." Unquote. The court therefore suggested legislative measures which would favor the implementation of the Uniform Civil Code. Again, in one of the famous cases, Muhammad Ahmad Khan versus Shah Bano Begum, the Supreme Court ruled that a Muslim husband is liable to pay maintenance to a divorced wife beyond the iddat period. The court regretted that Article 44 has remained a dead letter as there is no evidence of any official activity for framing a uniform civil code for the country. The court emphasized, and I quote, A common civil code will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies. Unquote. A decade later, in Sarla Mudgal versus the Union of India, the Supreme Court revisited the matter. The issue in question was whether a Hindu man who embraced Islam could solemnize a second marriage as a Muslim. The court said that in such a case, the first marriage would have to be dissolved under the Hindu Marriage Act 1955. A simple conversion to Islam followed by marrying again would not amount to such dissolution. The man's first marriage would be therefore still valid under the Hindu law, and his second marriage, solemnized after his conversion, would be illegal under Section 494 of the Indian Penal Code 1860. Justice Kuldeep Singh, delivering the judgment, remarked sharply that, and I quote, "The rulers of the day are not in a mood to retrieve Article 44 from the cold storage where it is lying since 1949. The governments which have come and gone have so far failed to make any effort towards unified personal law for Indians." Unquote. However, in Ahmedabad Women's Action Group versus Union of India, a PIL, that is public interest litigation, was filed challenging gender discriminatory provisions in Hindu, Muslim and Christian statutory and non-statutory laws. This time, the Supreme Court held that the matter of removal of gender discrimination in personal laws involves issues of state policies with which the court will not ordinarily have any concern. The Apex Court in Lily Thomas versus Union of India and others held, I quote, "The desirability of a uniform civil code can hardly be doubted, but it can only concretize when the social climate is properly built up by the elite of the society, statesmen among leaders who, instead of gaining personal mileage, rise above and awaken the masses to accept the change." Unquote. In 2003, in John Vallamathon versus Union of India, the court had reason once again to express its opinion on the subject of the Uniform Civil Code. In this case, Justice Khare commented, and I quote, "We would like to state that Article 44 provides that the state shall endeavour to secure for all citizens a uniform civil code throughout the territory of India. It is a matter of great regret that Article 44 of the Constitution has not been given effect to. Parliament is still to step in for framing a uniform civil code in the country. A common civil code will help the cause of national integration by removing the contradictions based on ideologies." Unquote. Again, the court, while considering the plight of Muslim women in certain circumstances in the decision reported in Kunni Muhammad versus Aisha Kuti, had the occasion to observe that, and I quote, "The legislature remains unconcerned and unfortunately no progress whatsoever has been made in regard to the Uniform Civil Code for obvious reasons." The court made it clear that Articles 25 and 26 are no impediments in promulgating the Uniform Civil Code, which is an absolute necessity, but some other considerations seem to deter the legislature from codifying laws and having a uniform civil code. Unquote. Also, in Somia and Thomas versus Union of India, the court, in para 33 of the judgment, observed, I quote, "Article 44 of the Constitution mandates that there should be a uniform civil code in India. All Indians ideally will have to come under the umbrella of the Uniform Civil Code, which will contribute to the creation of national identity and character." Unquote. Recently, the Supreme Court in Shaira Bano versus Union of India observed that the introduction of the Uniform Civil Code in India can be brought about by the legislature only. Pertinently, in this case, the Supreme Court declared triple talaq as unconstitutional. Clearly, despite the political ambivalence surrounding the issue, the Supreme Court's consistent advocacy in favor of Uniform Civil Code suggests that from a legal perspective, India may well be ready for uniform personal laws, and also that there is sufficient institutional competence and willingness for adjudication and administration of these new laws. The Supreme Court, through its various decisions, has favoured the implementation of the Uniform Civil Code and has urged the legislature to take the leap forward for unification of personal laws. Now, dear students, we come to the conclusion. Uniform Civil Code, as discussed already in length, advocates the unification of personal laws so that all the religious sects in India can be brought under one set of uniform laws. Uniform Civil Code, as many believe, will bring about national integration. Positive no to Uniform Civil Code can be deduced from the legislative reforms made from time to time and also from the many landmark judgments delivered by different courts, especially the Supreme Court, which have urged the legislature to adopt necessary measures for the implementation of the Uniform Civil Code. We have even seen voices being raised for its adoption from different political parties as well, especially the current BJP-led government, because they feel that such codification will produce a more coherent system of laws and the movement towards a more secular nation and will erase the menace of gender discrimination. But the other side of the coin is that it will also reflect a kind of tyranny of the majority and engender a great degree of divisiveness within the Indian society by annihilating and marginalizing the minority within the nation by depriving them of their identity, which is intact because of the presence of personal laws. It is pertinent to mention here the report of the Law Commission. The Law Commission has urged the legislature to first consider equality within communities between men and women rather than equality between communities. Submitting a consultation paper on the reform in family laws, the Commission has dealt with laws that are discriminatory rather than providing a uniform civil code, which is neither necessary nor desirable at this stage. The paper says most countries are now moving towards the recognition of difference, and mere existence of difference does not imply discrimination, but is indicative of a robust democracy. Observing that there is absence of consensus on the Uniform Civil Code, the Commission has underlined the need to eradicate discrimination. It said, and I quote, "This way some of the differences within the personal laws which are meaningful can be preserved and inequality can be weeded out to the greatest extent possible without absolute uniformity." Unquote. Thus, dear students, in theory, India of Uniform Civil Code may sound attractive and appealing, but practically, at least in the present, it seems impossible to implement it, as the task of devising a uniform set of laws related to the personal matters that will govern different religions, sects and communities is very daunting and onerous one, considering that the vast array of sentiments to be accounted for. Also, most of the personal laws derive their authority from religious beliefs, and keeping in view the sensitivity of the people of India to religion, it is prudent not to disturb them. So, keeping in view all these factors, it is better not to interfere with the personal laws of different religions, otherwise it will lead to catastrophic ramifications. Dear students, this was all about today's lecture on the Uniform Civil Code. Hope you have understood it well. We shall meet again with a new topic. Till then, take care of yourself. Goodbye.